Good day to you and welcome to another Paddocks Club tutorial. Today we're going to talk about Section 25 reservation documents and ask the question, what are they worth? Because the deeds registries will no longer examine them. This video tutorial is for owners, trustees and managing agents in schemes where there are outstanding future development rights. We're going to look at the issue of scheme extension. We're going to look at how extensions are defined historically. How did this process work? What has changed? What does this mean? And what can you do about it? The issue of scheme extension, I'll give you a quick summary. The developer, on opening the first phase register, imposes a condition entitling him or her or it to continue with the development, build further buildings, take out further rights to units and exclusive use areas in future phases. He puts in to define these rights various plans and schedules with the Registrar of Deeds at the same time as he opens that register. And these plans show the future buildings, describe the materials to be used and all that sort of thing. There's also a draft sectional plan showing how the buildings, the future buildings, are to be divided into sections and common property and any exclusive use rights that are to be taken out, and the effect on participation quotas so people can see exactly how their scheme is going to change and how it's going to affect them financially and otherwise. The registrar then issues a certificate of real rights to that developer, and that right is to build those buildings shown on those plans and get those ownership and exclusive use rights. Now, the developer is not completely stuck to exactly those particular rights, because you will see in terms of Section 25.13, a developer who exercises such a reserved right, that is to extend a scheme by adding further buildings, acquiring further rights to them and the common property, is entitled, while he's obliged to erect and divide the buildings into sections and common property strictly in accordance with those plans, he is entitled to change them if there are changed circumstances that would make strict compliance impracticable. And any owner of a unit in the scheme who considers that they are prejudiced by any change is entitled to go to court. Now, historically, how did this work? Who checked, though, that the actual plans that were lodged tied up with the reservation plans? How did the whole thing work? Well, it wasn't the Surveyor General's office. The draft sectional plans are approved without reference to the Section 25 reservation plans, which are in fact kept at the Deeds Registry. So then the approved draft sectional plan comes to the Deeds Registry, and the Deeds Registry examiners have historically checked those approved plans against the reservation plans to make sure that they tied up, and if they didn't, they refused to register them. That protected the owners, but it meant that the developer had to go to court to overturn the registrar's decision if he felt that it was unfair, if it wasn't just a blatant abuse of his rights, if he felt that he had an argument on the question of changed circumstances. So what has changed? Well, the short answer is a judge has held that the Deeds Registry must not inspect these plans. They hold them, but they don't have to look at them. In the Western Cape High Court, in the case Rose Park Admin CC and others versus the Registrar of Deeds, a very recent case just last month, the judge held that it's the duty of a prejudiced owner to approach a court. It's not the developer who's required to make that application. He confirmed that the Act doesn't expressly impose a duty on the registrar to approve the extension plan or not. In fact, the extension plan must be approved by the Surveyor General. In response to this case, the Chief Registrar of Deeds has put out a Chief Registrar Circular number 7 of 2011, confirming that from now on examiners will no longer need to examine sectional plans of extension. What does all this mean? Well, no official, neither at the Surveyor General's office, at the local authority, or at the Deeds Registry, will be examining the Section 25 extension plans after they are lodged or when they're lodged. But owners, trustees and managing agents can get copies of them from the Deeds Registry. And if they consider that the developer has exceeded the reservation rights, they must go to the High Court to get an interdict against the developer and the Registrar of Deeds to stop the registration. I'm going to give you a comment on this, in fact a few. The people with knowledge and understanding of sectional title measurement are at the Surveyor General's office. That's where those plans should be lodged, and subsequent draft sectional plans should be checked against them. I'm not saying that that the Surveyor General should necessarily become a judge in this, but certainly they should raise the issue and perhaps alert people if it looks as if those plans don't tie up and it's not merely a minor change. But not everyone agrees with me on that. I say that in advance. Most people, of course, can't afford to go to the High Court to fight the developer. But if vigilant owners, vigilant trustees, vigilant managing agents should be taking action much earlier than that. At the time when these buildings are starting to be built, that's the time they should be checking those plans and saying, no, this is going to go beyond what has been reserved, and then negotiate with the developer, try to avoid the situation where you have to go to court. Thank you very much for joining me in this Paddocks Club tutorial, and I look forward to chatting with you in the discussion forum.